This is Michael Popok, Legal AF After Dark, Daylight Savings Time edition. DC, Circuit Court, Judge Chutkan, Donald Trump. I don't know why I'm talking in monosyllabic type approaches to the stories on Legal AF, but this past Saturday on our weekend wrap-up edition, Ben Meiselas and me went into it, mano a mano, to talk about whether there should be a televised trial of Donald Trump when, not if, his case goes to trial in March. What's going on with the gag order? Judge Chutkan first imposed it, then she lifted the gag order, then she reimposed it, and now it's up at the Court of Appeals. What's going on there, Popok? Well, this is a good time to tune into an episode of Legal AF, and here's a clip right now.
Let's talk about what's going on in Washington, D.C. It's like a lot of activity there this week. We've got Judge Tanya Chutkan issuing an order. How about that, Popok? An actual order. That's a written order. That's a paper order, unlike Judge Cannon's paperless orders that have massive impact without citing law. We'll talk about that. But Judge Chutkan's order on the jury questionnaire, which signals that she's moving this thing forward. You've got Donald Trump seeking an emergency stay with the D.C. Circuit Court of Appeals. He drew a panel with 2 Obama judges and 1 Biden appeals judge. They granted the administrative stay, which is kind of administerial, hence administrative stay. And they made clear in that, don't read into this. This is not on the merits. This is the administrative process that the Court of Appeals just generally takes. So if you can go into that. And then, of course, we see Popok also, Trump trying to do everything he can to delay. He's filing a motion there to delay deadlines, and then a motion to stay the entire case with Judge Chutkan, which she's obviously going to reject, saying that the presidential immunity motion to dismiss that he filed, which is totally frivolous, means that the entire case should stop. He doesn't want that March 2024 trial date. I'm going to toss it to you, Popok, but the one thing I do also want to mention, though, is you see that Trump's overall strategy here, though. He's going to try to bring all of these motions, like the dozens of things that he filed, to the Supreme Court. And he's going to hope that on an emergency basis, he either draws a panel on the D.C. Circuit or the Supreme Court where someone steps in and stays the trial even a few months. That's his move with all of these moves. He knows Chutkan's going to reject him, but his move is to push all of these to the appellate department, the appellate court.
And we can talk a little bit about the difficulty of doing that. I did a hot take on the stay, and just to lower temperatures here among our audience, what the appellate court did, and it's a good draw for the Justice Department, not for Donald Trump. But what they did is exactly what Judge Chutkan did when she granted her administrative stay of her own gag order. After 2 weeks, she granted a stay of her own order to allow for full briefing, to have it litigated in front of her before she made her ultimate decision to re-gag him. Same thing at the appellate court. It's not uncommon. We've seen it. We've talked about it even at the Supreme Court level, where one justice that's responsible for a circuit will stay administratively, and nothing is to be read into it. In fact, they actually put the language in this particular order of stay. We'll start with the stay issue on the gag order, giving him effectively another, whatever it is, 17 days, whatever it is, to create more examples that this appellate panel will take judicial notice of when it comes time for them to make their ultimate ruling and to reimpose the gag order. The reason I am confident that they're going to reimpose the gag order is, one, because Judge Chutkan was right on the law as it relates to how you mitigate or how you synthesize the First Amendment with the Sixth Amendment, and how you just can't say anything if you're a criminal defendant in the criminal system whose liberty is at the discretion of the judge, and her threading of the needle was really appropriate given the case law and the precedent in DC. But more importantly, the standard of review, which I've talked about in prior hot takes, you and I have talked about it at length over the last 3 years of Legal AF, is really important here. And the standard of review favors the trial judge. The standard of review, appellate courts review decisions either with some level of deference to the trial court, no deference to the trial court, or different levels of burden or hurdles that the party bringing the appeal has to satisfy. And under this one, it's the lowest level. It's abuse of discretion. And the question is whether Judge Chutkan, in evaluating all of the evidence, conducting her hearing, reading the case law, did she abuse her discretion in imposing this gag order? Yes or no? It doesn't start from scratch. It comes from a standard of abuse of discretion. So that's what the appellate panel on the 20th of November with their oral argument, which we'll get an audio version of because we'll be able to get it from the website for the court. You know the questions they're going to ask this John Lauro, who's I'm guessing is going to argue at the appellate level for Donald Trump, which is tell me, so I understand it. Give me an example of something that your client could say that we could gag, because you're not going to take the position that nothing, because he's a political candidate with core campaign political First Amendment speech, he can say anything about anyone at any time related to the criminal justice system. So show me your limits. What are they? Give me an example. And they will spend a considerable amount of time with that. He either has to concede that there are limits, but they haven't been reached, or he's going to have to say there are no limits. Once he became a political candidate, the Department of Justice and the judge can't do a darn thing about it. He can say whatever he wants, regardless of its impact on the life and liberty of other people in the justice system. So I think that will ultimately sort out with him, just Donald Trump, not being able to help himself, creating new examples that this appellate court will be able to take judicial notice of when they reimpose a version or the entire gag order. On the trial date, there's full briefing that she'll handle again on the issue of whether the supremacy clause or any kind of presidential immunity means he can't be tried in the District of Columbia. And when she makes that decision, it'll go to another 3-judge panel of the D.C. Court of Appeals. It'll be randomly selected. It won't go to this panel because it's on a different issue. Doesn't arise out of the same issue. We'll get another panel. It's usually trends heavily Democrat president appointed. And then it'll be the same abuse of discretion standard to see whether that was an abuse of discretion to apply that or not. So again, deference goes tremendously to the trial judge in making their evaluation. And if they don't like, Trump doesn't like either or both of those decisions, as you said, Ben, they'll take it up or try to take it up with an emergency appeal to the U.S. Supreme Court. They have to get through John Roberts first, because Chief Justice Roberts is the sitting duty judge over the D.C. Court of Appeals. He's the one that has to make the first decision. He may do an administrative stay of some decision pending full briefing and turning it over to the full court. I doubt he will use the shadow docket to make the decision himself, especially given that it's Donald Trump. And if there's 4 people that are interested out of the 7 MAGA or 6 MAGA that are on the court, then they're going to get their day in court at the Supreme Court level. Although that doesn't automatically send a chill down my spine, because except for Clarence Thomas and Sam Alito, who you can put off to their own outlier status, most of this Supreme Court at the majority level, even with MAGA, has not supported Donald Trump's worst instincts and impulses about anything. Presidential papers, immunity, the Jan 6 committee, you name it. Only in very rare occasions have they sided with Donald Trump, and not on anything fundamental. So yes, but you're right. The question is whether the March trial date will be jeopardized. He's already done well, and we'll get to Cannon in a minute, with jeopardizing the May trial date, because she's already suggested she's going to be moving off in Mar-a-Lago that trial date. If somehow the March date slides and opens, then you've got hopefully a waiting Fani Willis in Georgia who's waiting to slot her case, and she's not going to be stopped by the U.S. Supreme Court. Or, of course, you've got still on the books and not yet officially removed the March trial date for Stormy Daniels against the case by the New York Manhattan DA. Manhattan DA, right, for the Stormy Daniels hush hush money business record fraud case. That's still officially on the books as a backup in March. So just like when you and I are trial lawyers and we have backup cases in the same court, Donald Trump has backup cases. He's double booked in March, right? With the trial for Chutkan and one right behind it that hasn't yet been officially taken off the calendar in New York. If May slides, you could have Fani Willis slide into that. But you're right. His number one strategy is to pull the pin on all of these trials so that he could have a clear line of sight to the November election and hopefully win office without having had to sit for a jury either acquitting him or convicting him.
That's his whole strategy.
Yeah.
It is not, let me put forward a defense because I'm innocent. It is not, in the New York Attorney General case, let me put forward evidence to rebut the accusation that this is a fraudulent enterprise. It's, let's attack the law clerk, let's attack the judge, let's just try to tear it all down. And fundamentally for me, where I think this Legal AF show is so important, I don't view that as political things. Like, I don't view it as, well, because I stand for evidence that should, it is right now, but that should be associated with a political party, and that, oh, if you're the MAGA Republicans, they're just, they hate evidence and they just make up crap. Like, that's a sad state of our body politic that something like that exists. And I just approach it as, okay, if you want to put forward your defense, Donald. If you say what you say, why is it that Mark Meadows took an immunity deal? By the way, Mark Meadows was just sued, and we were doing a hot take on this, and we broke the news at MeidasTouch.com. Mark Meadows was sued by his book publisher because everything he said in the book to the public that the election was stolen is a lie, where he told special counsel Jack Smith the exact opposite, under oath, under penalty of perjury as part of the immunity deal. Mark Meadows, according to all reports and accounts, which everybody believes to be accurate, including us here at the MeidasTouch Network, Meadows said, no, I told Donald Trump that the election was a free and fair election, that Biden won, that he lost. I told him not to do these things. And so Meadows lies to the public, tells the truth under oath. So where's your crew that's going in? Where's your evidence? Giuliani's invoked, is Giuliani going to be your witness? He invokes on some, he just completely lies on others. He doesn't even show up for his case in Washington, D.C. So he got terminating sanctions and a default entered and an adverse inference on the issue of punitive damages because Giuliani doesn't even provide documents. Who is your crew of people who are giving evidence, actual evidence? And that's, to me, the most critical thing here. One thing I want to say, though, where I agree on a lot of things special counsel Jack Smith does, the one thing that I really disagree with him on, I understand why he did it, because everything he does is just textbook. I follow the law. Here's what it says. This is my position. We're not being creative with the law here. And the law in federal courts is that there is no video recording of the trials. So I think just to be intellectually consistent, Jack Smith's not going to deviate from what the law is, because his whole thing is whatever the law says, that's what I say it is. And I'm not going to propose something creative here. We're not in the business of deviating with, even if there should be media. So Jack Smith just cited the law. Here's what it is in federal court. And we're just, here, Your Honor, what the law is. And Donald Trump, who said that he wanted the cameras in there. The first thing that John Lauro, by the way, I'm not sure Lauro is going to be doing the appeal, because I don't think Lauro had at that point in time, or at least as of a few weeks ago, actually been barred to do the appeal. He's barred in other states and as a lawyer in other places, but not with the DC.
I assume he got in the last 2 weeks.
Yeah, but Lauro said the very first thing we're going to do is demand that this case be televised, and they did not demand it be televised. They said they take no position. I disagree with Jack Smith there, but it's easy for me to make that argument as someone who hosts a podcast and who hosts and who runs a media network and who does TV shows, and that I wanted to, but I think it's important that people see this testimony, even if, and I think the federal law is wrong on this. We see with Judge McAfee in Georgia, this can work in an orderly way. We, the people, deserve that transparency. But I do understand that Jack Smith's just citing the law right there. I want to get your take on that, Popok.
Yeah.
One final point I'll make, though, is the same way that, I think with Jack Smith, his view is like, look, if I am not intellectually and legally textbook consistent here, let's take another issue like SIPA, the Classified Information Procedures Act, where Donald Trump's lawyers consistently tried to argue something that's convenient for them, that they want access to potential classified documents in the Washington, D.C. case. And I, Jack Smith, am arguing that SIPA clearly says this. Will I be losing credibility on future motions if on another motion where it was convenient for me to want the media, I make that argument? Do I lose my gravitas within the court of intellectual consistency? And that's where I think he's coming from. And so just Judge Chutkan said when Donald Trump's lawyers wanted to access classified information in the motions and tried to deviate from SIPA Section 4 procedures. I've done so many hot takes on this, I won't belabor it. You're probably sick and tired of my SIPA analysis, all the legal affers out there. But Judge Chutkan was basically like, no, SIPA Section 4 says that these things should be filed without the involvement of the criminal defense lawyer to avoid what's called gray mailing, where the criminal defense will get access to sensitive documents that may harm our national security and try to leverage that to get the case dismissed. On the other hand, Judge Cannon completely ignored SIPA Section 4 procedures, and Judge Cannon basically said, I'm just going to go by what the SIPA Section 3 protective order says. I'm going to ignore that there's this Section 4 procedure entirely, so you can make individual motions. She's just making Jack Smith's life more difficult. File individual motions for me. I'm giving my own interpretation of what SIPA Section 4 says, even though I've never done a SIPA case before. And she like does this like tortured statutory interpretation, which makes no sense. But we've done that hot take over and over and over again. But my point is intellectual consistency, Pope. I think that's why he did it.
Yeah, no, I agree with you. And by the way, watching Cannon, trying to make her way through SIPA and all these other complicated issues is like watching a baby in a high chair eating solid food for the first time. I mean, she's just making a mess. And it's just giving Jack Smith's team, he's got appellate lawyers that actually sit with the trial lawyers on a daily basis to talk about how to set up the record properly for appeal. And he knows he's got an 11th Circuit that's just champing at the bit to get something from her, because they've already slapped her twice when she tried to interfere with the actual criminal investigation. It seems so long ago, of a year ago in August, when there was a raid or an execution of a search warrant on Mar-a-Lago, and she decided to get in the middle of it because he was a former president, and she created a whole new class of imaginary precedent that doesn't exist to protect him from a criminal investigation before it was even completed. So she's got no friends on the 11th Circuit when it comes to how she's been handling the case. And I would love to see all of your SIPA knowledge come to fruition and being used at an 11th Circuit appellate hearing status. I don't know if I disagree with you, but I am comfortable with the reason that the federal court rules, which have been on the books for a long, long time, and Supreme Court precedent going back to the 1960s, does not allow federal courts trials to be televised.
Keep going, Popok. I'm about to get the Popokian fans over to my side now.
I know. I'm a child of the O.J. Simpson trial. I think you were in high school, and I was a lawyer. I was a lawyer. I was in middle school. You were in middle school, right? There was a lot of it made a lot of careers, and I get it from a media standpoint. And there's people that you would never have heard of today, like Greta Van Susteren, and aspects of CNN that you would never have heard of if it wasn't been put on the map by the OJ trial. And I get it, but it was also a cluster F from the presentation of the case, and there was a lot of mugging for the camera and a lot of inappropriate things that went on in the courtroom and it wasn't a brand of justice that I was comfortable with. Now, look, I'm a legal commentator. I've been doing this with you for a long time. I would love the content, trust me. And the alternative of having people that get into the courtroom and then we report the people that are reporting from the courtroom, it's very convoluted, but it hasn't gotten in the way of us being able to analyze what's happened in real time. If we can get video, we get video. If we get transcripts, we get transcripts. If we get people that are taking really great notes, we get that. And then we're able to do what you and I do, and with Karen, we do our deep thought analysis, analytics, and almost like essayists about what we just observed. I get that the raw feed being pumped into people's brains directly, but I just don't think it's a good thing. Knowing Donald Trump is constantly trying to overthrow not only democracy, but the justice system, giving him an ability to do that on national television and whoop it up with his followers. I'm not sure that's the dignified justice system for criminal justice that I want to see. But that's me. That's my opinion. But I don't think that there's going to be any way to televise this. I think if both parties agreed, she would have allowed it. But if both parties are not going to agree, and now the Department of Justice doesn't agree, it's not happening. Not happening.
So for those of you whose favorite host on Legal AF is Michael Popok,
Michael Popok.
I want to let you know that I'm here for you all.
God.
That even though I was in middle school when the O.J. Simpson trial, let's move. Just joke, Popok.
All right, if you like that, then you're going to love the long format podcast called Legal AF. Yes, it's what you think, only on the MeidasTouch network. We do it just like that. On Wednesdays, I do it with Karen Friedman Agnifilo. She's got 30 years of prosecutor experience. I got 30 years of defense attorney experience. And then on Saturdays, Ben Meiselas, longtime civil rights lawyer and co-founder of the MeidasTouch network itself, joins me. And this is what we do. You know, we bat that shuttlecock back and forth, talking about legal issues from our own experience as professionals. We don't blow smoke or sunshine. We just bring it right to you right here exclusively on the MeidasTouch network. So if you know all about us already, welcome back. If you don't know anything about Legal AF, that is an example of it. And if you'd like to get other people to know more about our show who aren't inclined to make the hour commitment of the full podcast, send them this clip and help this network continue to grow. It's grassroots movement, no outside investors. Free subscribe to the MeidasTouch network right here. The bigger they get as a platform, the more your voice is heard. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.